Hi everyone, welcome back to my channel. So today I do have a video of Chilly for you. There's only a small part in one of his videos that I picked out of it because everything else in it is just common sense. You don't need his creepy little trifold to even have common sense, but obviously Chilly doesn't have common sense and neither do his followers, so they need this trifold to use when in traffic stops. That said, the one thing he seems to focus on again is this whole legally allowed to park on the side of the highway. And again, we all know that that's wrong. We all know that you cannot legally just park on the side of a highway or an interstate for no apparent reason other than an emergency. But wait until you see how he tries to present this law or this case law, because again, it just shows how stupid he is. Enjoy the video.
Is for everything.
Sir, you can film all you want, but I can't have you parked on the highway here.
I can park on the highway, officer.
Can't you see you're impeding traffic right now? I need you to get off the highway.
I can park on the highway, officer.
Listen, I need you to get your van off the highway.
Oh my God.
I can just tell them to read this, or I can read it for them.
Unfortunately, no. Sorry. His trifold is not going to save you. And if his trifold is like your best friend, then you obviously need to get out more and start meeting some people, because his trifold can get you in trouble. Let's take a look at it.
I can just tell them to read this, or I can read it for them. And this is how you protect yourself. I usually just keep this in handy. I keep this in my car, and every time I get pulled over, this is like my best friend.
Sure, you can, ask the officer to read this creepy little trifold, or you can read it to them, but they're still going to look at you like you're dumb and continue with the traffic stop. Also want to just state this right now is if he's going to give an example, okay, of whatever thing he's put on his trifold claiming it's case law all over the country and it stands, yeah, you're on a city street, so you can park on the side of the city street as long as there's no parking signs. I mean, if he wanted to actually do an example of this no highway stopping, he should have taken it out to the highway. But he's too dumb and lazy, obviously. I'm not sure. But again, he has no clue what Teshline versus whatever it is. I can't remember now. He doesn't understand that case law, period. He just does not understand it. He thinks he does, but he doesn't. And I'll go over that when I go over the little trifold thing. Okay, so here we have Chilly little on the trifold. Is that a threat? Chaplinsky versus New Hampshire, 1942. Charge was offensive words. Held certain words are exempt from the First Amendment protection when they instigate violent reactions by listeners. That's what was held. Okay. Instigate violent reactions by listeners. Now, the fact is, this guy did say to police officers, you fascist or damned racketeer, and are labeled as fighting words by SCOTUS. That is correct. Now, Chilly's fact, and I say that it's Chilly's fact, which makes it Chilly's opinion, is that I can and I will use any words or set of words that I feel are appropriate. Fighting words are clearly not what I'm using. It's not just about fighting words. That's what I don't understand. I understand it. That's what Chilly's not understanding, is in his little bitty mind that barely functions on a daily basis, is that according to him, only fighting words fall under this. And that's not true. So, okay, yes, facts about the case are on a public sidewalk in downtown Rochester, Walter Chaplinsky was distributing literature that supported his belief as a Jehovah's Witness and attacked more conventional forms of religion. Chaplinsky called the town marshal a GD racketeer and a damned fascist. He was arrested and convicted under the state law that prohibited intentionally offensive, derisive or annoying speech to any person who is lawfully in the street or public area. On appeal, Chaplinsky argued that the law violated the First Amendment on the grounds that it was overly vague. Writing for a unanimous court, Justice Frank Murphy upheld Chaplinsky's conviction. The court identified certain categorical exceptions to First Amendment protections, including obscenities, certain profane and slanderous speech, and fighting words. There we go, Chili. So where Chili is saying that the only thing they can uphold is fighting words, that's not true. Obscenities, certain profane and slanderous speech are also included in this exception to the First Amendment. Those things are not protected by free speech. He found that Chaplinsky's insults were fighting words, since they caused a direct harm to the target and could be construed to advocate an immediate breach of peace. Thus, they lacked the social value of disseminating ideas for the public that lay behind the rights granted by the First Amendment. A state can use its police power, the court reasoned, to curb their expression in the interest of maintaining order and morality. Is obscene speech illegal? Obscenity is not protected under First Amendment rights to free speech, and violations of federal obscenity laws are criminal offenses. The U.S. courts use a three-pronged test, commonly referred to as the Miller test, to determine if given material is obscene. Now, let's take a look at an example of Chili using obscene and possible fighting words towards police. In my opinion, he should have been arrested for this, for breaching the peace, and for disorderly conduct. But it's California. We all know how police officers are in California.
I bet within 2 years you have no. No, I'm not going anything. Don't, hey, get your hands up. Don't touch me, brother. Don't put your hands on me, mother. You better back the up. I'm standing right here. I'm not going anywhere. Keep your hands off me. Rodriguez versus United States, 2015. You're extending this, which is unconstitutional. Leave me the alone. This is a First Amendment protection activity. Put your hands up. Do what you want. But I'm not moving an inch. I'm not moving a inch. Go ahead. This is Rodriguez versus United States 2015. You dunce. No, I'm standing right here. What are you going to do about it? Do it. Then do it. PC. Go ahead. Go ahead. And you'll lose your badge in 2 years. I sue lots of cops. Your stop is right here. Rodriguez versus United States. Let me help educate you. Just back up to right there. I'm not moving. You don't have dominion over me. Pig. Get the away from me. I'm standing here filming. I'm doing my job.
Okay, well, first of all, we all know that none of that had anything to do with the case law he was screaming out, but his behavior, his obscenity, the way he was yelling at the police officer, absolutely breach of peace, disorderly conduct. He should have been arrested for it. I wish I had been that cop. He says that he can use whatever words he wants, as long as they're not fighting words. Well, you know what? Actually, if you took that to a court, they could actually say that you were enticing the cop into a fight. Honestly, with some of the words that you were using. I don't care what Chili says. He's a dumbass. He doesn't understand anything anyway. And he usually only abuses police officers in this manner while he's in California, because California cops are so relaxed. Let him try saying stuff like that to a cop in Texas or in Kentucky or Ohio or wherever else. Although we know he won't go back to Ohio because he has 2 warrants out for his arrest. Anyways, let him say that to another cop, mainly in central U.S. and eastern U.S. The cops won't be as relaxed as they are in California. He is an idiot. Do not follow his creepy little trifold. Do not follow his example, because you can get in trouble and you can get arrested. And he's not going to help you in any way. He thinks he does, but all he's doing is hurting. Okay, so now we have Let Me Talk, which is going to fall pretty much similar under Is That a Threat? It was Houston versus Hill, 1987. Charge was interrupting a cop. Held a certain amount of expressive disorder is inevitable in a society that's committed to individual freedom and must be protected if the freedom would survive First Amendment. Okay. His fact, and again, let me remind you, when he puts the actual case law held, that's the fact. When he writes the word fact and then writes next to it, that's just his opinion. It's not a fact. He needs to fix that because at this point, he is selling purposeful misinformation. Sorry, I'm hitting my phone screen with my finger. He is purposely selling misinformation knowingly. Okay? And that's a big no-no. The whole Houston versus Hill 1987 does not mean interacting or interrupting police is your God-given right. That's wrong. It's absolutely wrong. There are limitations to the First Amendment. There are exceptions to the protection of the First Amendment. And I just went over that in the last one. So I'm not going to go over it again. Where he says, Officer Mr. Hill interrupted police as they were doing their job. I have every right to speak over you if I need be. Oh my God, it has nothing to do with speaking over a police officer. It doesn't. Again, Chillie proving he's an idiot. Okay, so now we have another part of his creepy little trifold, whereas the revoke consent. He is right about that. You can revoke consent. Let's say you get pulled over and the cop asks you if he can search your vehicle and you say yes. At any time after that, you can revoke that consent. However, the minute you are arrested and in handcuffs, it doesn't matter. They can then search your vehicle. Now, Chillie uses case law U.S. versus Williams, 2018. And, well, again, this just proves he has no clue what he's talking about when he reads these case laws. He's not understanding a word that he's reading, and then he tries to use this case law on something he's trying to say, and the case law has nothing to do with what he's talking about. Here it says, U.S. versus Williams, 2018, charge distribution held because the subject of a consensual search has control over the search perimeters, he can restrict or terminate it entirely. That is true. Fact. Again, usually Chillie's facts are opinions and feelings, but he is right about this. To revoke consent to clear a search, you must make a clear position. We all know this. It's common sense, okay? However, in the case law of U.S. versus Williams, it has nothing to do with what he just wrote here. Okay, so this is the case law for United States versus Williams 2018. It was decided January 24th, 2018. Facts and procedural history. Defendant, appellant Gross Williams, was convicted in 2012 in Iberville Parish on state charges of distributing marijuana and placed on 5 years of probation. Conditions of Williams' probation included permitting home visits from a probation officer, refraining from owning or possessing firearms, and consenting to probation officer searches of his person or property at any time with or without an arrest warrant. Specifically, Condition 13 of his probation conditions proved or provided that Williams was required to agree to searches of his person, his property, his place of residence, his vehicle, or his personal effects, or any or all of them, at any time by the probation officer or the parole officer assigned to him with or without a warrant of arrest or with or without a search warrant. when the probation officer or the parole officer has reasonable suspicion to believe that Williams is engaged in or has been engaged in criminal activity. Sorry about that. I put it on Do Not Disturb, so I'm not sure why it keeps slipping through there. Probation Officer Patrick Green testified that during the term of Williams' probation, he was a model probationer, and as a result, in 2014, Officer Green began the process of drafting a petition for cause to request that the court terminate Williams' probation early. While Officer Green was writing the petition, he received a call from his district administrator to report to his office where a meeting was being held with the Drug Enforcement Administration, or DEA. Officer Green was then informed that the New Orleans Police Department and the DEA had determined that Williams was involved in the narcotic trafficking of large amounts of heroin. Officer Green testified that he was shocked at the news. As a result of the tip from the NOPD and the DEA and his knowledge of Williams' prior criminal history involving drugs, including the offense for which he was currently on probation, Officer Green concluded that he was warranted in conducting a compliance check on Williams. Officer Green called Williams and asked him to come to his office, but Williams said he could not leave his dealership because he was the only person there. Consequently, Officer Green, along with several other probation officers and law enforcement from a neighboring parish, traveled to Williams' car dealership to begin the process of the compliance check, which would traditionally involve transporting Williams to his home to further investigate further. When he arrived at the dealership, Officer Green testified that he walked up to Williams and noticed that he had bulges underneath his clothes. So he asked Williams, "Do you have anything on you I need to know about? Anything illegal? Anything sharp? Anything that could hurt me?" Williams replied no, but then he stated that he had cash in his pockets. Officer Green testified that at that point, he Mirandanized Williams and then started to conduct a frisk, a pat-down, in which I felt large objects underneath in his pockets. I then removed those objects, and they turned out to be wads of cash from both his shirt and his pants. And the reason I removed those is I wanted to see if there was any weapons on the other side of him with the large bulges. I could not tell what else was in his pockets. Officer Green testified that as a result of the pat-down, he found in Williams' shirts and pants pockets wads of cash that had been folded over in half of varying denominations, ones, fives, tens, 20s, and 100s. Not all of it in the same numerical order and varying amounts in different pockets. Officer Green continued, "I asked him where the money came from, and he told me that the money had come from the car dealership, from him selling cars. Although Williams had estimated that the cash totaled approximately $14,000, law enforcement counted $10,000. Officer Green testified that he found this large amount of cash odd, since Williams had previously reported that he made approximately $2,500 per month in income. Officer Green further noted that it seemed strange that Williams had reported that he was alone at the dealership, but when officers arrived, Williams' wife was there. Thereafter, Officer Green continued conversing with Williams and obtained his consent to search his business. Now, let's keep in mind that Williams is on probation. And with his probation comes with the fact that they may search him, his person, his home, his property, anything, anytime, by anyone as long as they are a probation officer or law enforcement. This is part of his probation. He has to follow that. The fact that he got consent from Williams was amazing. But Green really didn't even need the consent. He absolutely didn't need the consent. The consent was already there because of the probation that Williams was on. So basically, that's what this is all about. He ultimately answered a guilty plea, blah, blah, blah. But the whole thing comes down to Chillie is trying to say that this case law is something it's not. Again, proving Chillie will read parts of case law, thinks he's understood it, twist his feelings and his opinions into it, and create a whole new case law that's not even actually law. Okay, so now we have this part of the weird little trifold I smell marijuana, Commonwealth versus Barr 2021. Just like with our favorite little one that he likes to use constantly with the parking on the side of a highway, this does not stand as law in all states. It's only in a few states. There are still many, many states that it is legal for the police to search your car with the probable cause of being, when they smell marijuana, they're allowed probable cause to search your car. Now in Pennsylvania, that's no longer true. So for Chillie to have this on his trifold where he's trying to use these as nationwide case laws that you can use in any state, he is wrong here. And if you live in a state that does not follow this law, that follows the law that yes, smelling marijuana in your car is probable cause to search, then if you show them this dumb little trifold, they're going to look at you like you're dumb because, well, you are if you're using it in a state that does not have that law. Again, just shows that Chillie does not understand law or case law, period. Okay, and now we have this one. No highway parking. Our favorite. The one that Chillie loves to throw out in every state that he goes in and parks on the side of the highway or an interstate and likes to scream out, Touchline versus Danforth. And every cop that he screams that to looks at him like, dude, you are mentally challenged. Because, again, this only stands up in the state of Mississippi. And even in the state of Mississippi, you cannot just park on the side of a highway or an interstate for any reason other than emergencies. This doesn't even have to do with that. This was a case law that had to do with a bus corporation. I mean, you can read it. I've gone through this before in several videos about this Touchline versus Danforth. Again, I will say it for the 100th time. Chillie does not understand what he reads about this. And if you live in any state other than Mississippi, and probably in Mississippi as well, and you get pulled over or you pull over to the side of a highway or an interstate, and an officer tells you you can't be parked there unless it's an emergency, and you show him this on a trifold, they're going to look at you like you're dumb. Because guess what? You're dumb. So again, he's putting this on there. Just keep in mind, anybody who's buying these stupid trifolds, they are all incorrect. Everything on them is incorrect. Now, he may have certain case laws correctly. However, the problem with that is these case laws that are stated correctly are only for specific states. So, just like the one I showed you prior to this one, if you don't live in that state, it has nothing to do with you. He is literally just throwing trash together on a, what he says, indestructible trifold, which I'm pretty sure I can cut in half with scissors. If not, I'm very, very skilled with a hacksaw. I'm sure I can literally chop it up with that. He's selling these for $25 in color, $5 if print. You're buying garbage. Okay, you're throwing your money away on something that will not save you in a traffic stop or anything really, unless you live in Pennsylvania and they smell weed coming from your car. But you know what? You don't need a trifold to tell the cop that. A lot of that is just common sense if you live in these certain states. The point is, he's lying as usual. He made this big uppity thing about how amazing this new trifold was going to be, and it's the exact same bullshit as the last trifold. Only he's updated a couple years that were on some of these case laws. But still, he's wrong on case laws, wrong on states with case laws, and he's just proving he doesn't know what he's talking about. And anybody who takes advice from this dumbass or takes this trifold and tries to use it, whatever bad happens to you, you only have yourself to blame because you were not bright enough to get online and fact check this dumbass. We also just take a moment here to take a look at how wrong he has this entire part of his trifold. As far as the Touchline versus Danforth 1987, the charge, yes, was vehicle obstruction. Held was not the right of a citizen to travel on a public highway equates to life, liberty, and the pursuit of happiness, which actually is not even part of the Constitution. And that fact, which again, as I've already pointed out, when he writes fact, it's not a fact. It's actually just his opinions and his hurt little feelings. Travel is also the right to stop on the way for a legit or necessary purpose. This is called an incident to travel. No, not when you're on the side of a highway or an interstate. No. Again, we all know that this is only in Mississippi, and this goes for something totally different, not on this. That Chillie read it and thought, oh crap, I can turn that into something that's going to benefit me and make it sound like this is real, and my followers aren't going to fact check me anyway, so it doesn't matter. I can lie, I can put it together, put all my feelings in there, and it'll go great. And that's what he did. It's what he does on all of them. I just wanted to point that out again. Like he says here, Danforth ties my right to travel directly to our founding principles. I'll stop, pull over as needed. No, Danforth does not tie your right to any of that. So there you go. Chillies Trifold, his new one, is the same as his old one, only the colors are more vibrant, and that's about it. Same misinformation, same lies, same confusion, same bullshit as the last one. He's right, he'll never stop. He'll never stop giving misinformation. He'll never stop lying to his followers because it's the only way he can get attention and money is by lying. He has them so brainwashed at this point because he has convinced them of all of this and it being true. And not one of them bothers to fact check him. If one person out of his followers would just fact check him and then let everybody else know, then that might actually take Chillie down. But for some reason, either his followers don't know how to use the internet or they're afraid to find out the truth, because if they find out the truth, then they realize they're as dumb as he is because they believed him all this time. I don't know. We will never understand because we are not like them. We are free thinkers. We know how to use our brains. We're not afraid to use what God gave us, and that is our intelligence. We will fact check. It blows my mind that these people don't even bother. Anyways, I hope you enjoyed the video. I will see you in the next one. Be safe, take care, and I love each and every one of you.